But there's something even more troubling than our police pursuing the forensic advantage of delayed charging of suspects in countries like Indonesia. In the case of the Bali Nine, a judge of our own Federal Court of Australia commenced his judgment suggesting there was a need for the Minister to address the procedures and protocols followed by members of the AFP when providing information to the police forces of another country in circumstances which predictably could result in the charging of a person with an offence that would expose that person to the risk of the death penalty in that country. His Honour Justice Finn said, "Especially is this so where the person concerned is an Australian citizen and the information is provided in the course of a request being made by the AFP for assistance from that other country's police force." Since that judgment, the Minister and the Police Commissioner have said that they see no need for a review of the protocol and processes. The Commissioner has gone one step further and said there is nothing the police can or ought to do in response to a parental request for assistance. According to Mr Kilty, if anyone connected with the police did respond positively to the parental request, that person would be acting dishonourably and corruptly. Mr Kilty has told Parliament, what does that say to the parents of the other children who did travel? That because someone had a mate in the police, they got rescued, but their children are subject to the circumstances of the Indonesian judicial system. It's simply a nonsense to even project that as being a way that the AFP should operate, he said. Bob Myers, the Brisbane barrister and family friend who had contacted the police on the behalf of the parents of Scott Rush, laments, "Certainly, I know with hindsight now, you can't rely on our agencies, Australian agencies, to help us out in a crisis of that sort." Mr Myers had requested the AFP that if Scott did intend to depart Australia, he be informed that the AFP was concerned that he would be up to no good and that his activities outside of Australia would be monitored. Myers had no doubt that Scott would be approached and spoken to. He informed Lee that this would happen and expressed to him the thought that after Scott had been spoken to, it would be unlikely that he would involve himself in criminal activity. All right-thinking people applaud the efforts of law enforcement authorities taking a strong stand against those who exploit and profit from others' addiction to illegal and harmful drugs. But some of the most honourable and non-corrupt law enforcement officers are those who can take the young person aside and warn them off. This cannot be done in every circumstance when an anxious parent seeks assistance as a last resort. But our sense of legalism is too stretched when the Police Commissioner can proclaim that any such instance of this sort would be dishonourable and corrupt. We can maintain a respect for the noblest human aspirations, including parents' desire to protect their child, a friend's desire to help a mate, a free and confident nation's desire to spare even their foolish, selfish citizens from the firing squad. The Federal Police should be empowered to do their job, but their desire to track down criminals and their willingness to sacrifice the life of our citizens should not permit cooperation with other police beyond what would be permitted were other police in a common law country where charges would be laid earlier than they are in countries like Indonesia. The distinguished Victorian Supreme Court Judge, Murray McInerney, told me when I was admitted to the bar 30 years ago that there was no finer citizen than the good police sergeant in a country town who was able to keep the peace, not primarily by enforcing the law, but by having a quiet word to the young fellows around town. There must be a place, even in our federal police, for cooperation with parents and citizens of good standing, wanting to avoid the firing squad for their children and for their friends' children. In his speech, entitled "Don't Bury Us Before We're Dead," at a conference in Bali this last July, Colin MacDonald, QC, counsel for Scott Rush, put two suggestions for moderating AFP operational behaviour more consistent with Australian values, including espousing the right to life. These were his two suggestions. The first practical suggestion is for Australia to domestically legislate and incorporate into domestic law the second optional protocol to the International Covenant of Civil and Political Rights. This practical step would prevent any government in Australia in the future, in the law and order auction of Australian politics, from reintroducing the death penalty. It would also ensure that the exposure of an Australian citizen to the death penalty was a relevant legal consideration in administrative decision-making which might expose such a citizen to the death penalty. The second practical step involves the writing of one letter by the Minister for Justice to the Commissioner of the Australian Federal Police, pursuant to the Australian Federal Police Act. That letter would be a direction to the Commissioner that AFP members are not to intentionally and predictably expose Australian citizens to the death penalty in AFP operations. Under the same Act, the Federal Commissioner is obliged to comply with such a direction. Such steps could ensure that the AFP would be able to take more notice of nobly intentioned interventions such as that made by Lee and Christine Rush and their friend Bob Myers. The arbitrariness of the death penalty for Scott Rush is highlighted by the life sentences given to the other 3 drug mules in the Bali Nine, and by the paucity of reasoning offered by the Indonesian Supreme Court, which made no effort to analyse why death was warranted for Scott Rush and not for the other mules. Scott Rush does not deserve to die. He did not commit the worst of offences. He's been arbitrarily singled out for the death sentence by the Indonesian courts. His criminal act, if successfully executed, would have caused direct harm in Australia rather than Indonesia, and our courts would probably have imposed a 10-year sentence with a minimum of 5 years to serve. Should Scott's final appeal to the Indonesian Constitutional Court fail, the Australian government should plead clemency, not just because we oppose the death penalty in principle, but also because a death sentence imposed in these circumstances would have adverse consequences for us in the fight against illegal drugs. Let me explain. This death sentence would either unreasonably hamper Australian law enforcement officers cooperating with Indonesian authorities in busting future drug rings attempting to move drugs from Indonesia to Australia, or else it would place Australian law enforcement officers in the invidious position of routinely handing Australian drug mules over to death regardless of our principled opposition to the death penalty. Killing our impressionable young drug mules, even at Indonesian hands, is too high a price for Australia to pay in combating the importation of illegal drugs. Our government should stop the AFP from cutting corners when it comes to the death penalty. John Howard and Kevin Rudd should make it clear to the Indonesians that we can cooperate closely in defeating drugs, providing only that the Indonesians respect our opposition to the death penalty, especially for what ought to be non-capital offences. Let's hope, pray and work to do what we can to spare the lives of Scott Rush and all those sentenced to death by the state when there are non-lethal means available to protect us from their past or future wrongdoings, whatever they may be, whatever they could be. Justice must not kill.